My name is Isaac Christopher Lugo, and today I would like to make a dispensation in terms of when the state defies its own seal, in terms of the whys, the hows, and the legal consequences that can ensue out of such a challenge. I would like to offer, first of all, in terms of a rebuttal, in light to His Excellency's argument of the delay, as far as Dr. Kiiza Besigye's formal court proceedings were due to institutional challenges in transferring the case from the military court to a civilian court, and that the blame basically lies with Besigye's lawyers rather than the government. In my opinion, this has to be grounded in constitutional law and in light of human rights jurisprudence and also procedural fairness. Okay, let's first of all do judicial dissection of the constitutional debate that may ensue in this case. Let's first of all argue in light of the violation of the right to fair and speedy trial as envisaged under Article 28 of the Ugandan Constitution. For starters, we shall argue and comprehend that the Ugandan Constitution under Article 28, Subarticle 1, guarantees that every accused person, yes, has a right to a fair, speedy, and public hearing before an independent and impartial court. Not so. And the argument that institutional challenges are to blame ignores the state's obligation, okay, to ensure that the legal framework functions effectively in terms of upholding what they call fundamental rights. And therefore, the burden, in my opinion, is on government, not on the accused or their lawyers, to ensure that cases are handled expeditiously, especially where a fundamental right in terms of violation trial before a military tribunal has already been identified. So, Your Excellency, we disagree on that particular component. Yes? Let's look at another component. We could argue in light of government's duty to implement constitutional court as far as Article 137 of the Constitution is concerned. Your Excellency, let's put these things in terms of constitutional debate. Once the Constitutional Court, Your Excellency, has ruled that Besigye should actually be tried in a civilian court, it becomes government's legal obligation to ensure that the transition was actually seamless. That is something we need to comprehend. The doctrine of separation of powers does not excuse the executive agencies from enforcing judicial orders. So any delay in implementing constitutional court ruling is a constitutional violation for which the government, Your Excellency, is responsible. We're just debating these things in terms of constitutional debate, Your Excellency. Let's also argue in light of something else that you propounded, Your Excellency. In light of Besigye's lawyers that cannot be held liable for government inertia. That is something that is substantial for us. In my opinion, I'm arguing that the claim that Besigye's lawyers are to blame misplaces the burden of legal obligation. How? It is not the duty of a private legal team to manage bureaucratic processes of the state. The judiciary, for example, in terms of prosecution, in terms of relevant state agencies, bear primary responsibility for ensuring due process. So the idea that Besigye should actually have instructed his lawyers to expedite the process implies that his lawyers had power over state institutions. That, in my opinion, is an absurdity in terms of constitutional democracy. And again, that is something we have to comprehend, Your Excellency, in light of what we're trying to debate here. Let's talk about the right to protest. You brought that also vehemently in terms of the right to protest, in terms of hunger strike, as a legitimate, in my opinion, as a legitimate form of political expression. Yes? Under Article 29, for example, of the Constitution, every citizen has a right to freedom of expression. Yes? And also thought and assembly. So, in my opinion, a hunger strike is a peaceful, non-violent means of protesting an injustice and is a globally recognized form of civil resistance. If state institutions delay justice, an aggrieved person is entitled to draw public attention to their plight through peaceful means. And so, Your Excellency, your assertion that Besigye should seek legal avenues instead of appealing for public sympathy disregards the fundamental role of public accountability in a democratic governance. Again, that is something Your Excellency would like to put to bed so we comprehend and argue in terms of this so beautiful constitution that you brought into being. Let's also argue in terms of the legal precedent, in terms of unlawful delays, as a violation propounded under Article 23, Subarticle 6 of the What? On pre-trial detention, for example. Yes? Uganda and international case law consistently holds that excessive delays in trial violate, fair trial rights. Yes? And also the African Charter on Human and People's Rights, which Uganda has actually ratified, particularly under Article 71D prohibits unjustified delays in judicial proceedings. Courts have ruled that when the state is responsible for such delays, the accused must be released or have the charges dismissed. A good case again is one of Uganda versus Besigye, which was 2005. Please, you need to remember that very well. Let's also argue, in light of the military court's lack of jurisdiction over civilians, which just came out recently, not so, as an inherent violation of a fair trial standard. Yes, we cannot debate anymore on that because we brought light to this and the Supreme Court pronounced itself on that. The constitutional ruling directing Besigye, for example, transfer to civilian court was actually based on the principle that military courts lack jurisdiction over civilians. Yes, and therefore any delay in effecting that ruling only prolongs the violation of his rights, reinforcing the argument that government is at fault, not the defense. Let's call a spade and not a big spoon. In my opinion, the state is solely responsible for any delay, and that should not be imputed on Besigye as an individual or even his law or her lawyer or his lawyer for that purpose, because I know they are represented by quite some substantive fervent force, including wonderful women lawyers. Now, given the constitutional mandate in terms of enforcing judicial decisions, the state's argument of institutional challenges is legally indefensible, in my opinion. The executive cannot absolve itself of responsibility when its own institutions fail to execute these so-called court orders. Yeah. So, in my opinion, Besigye's hunger strike is not an appeal for sympathy, but a lawful exercise of his right to protest against judicial injustice. Thus, the government must make or even take full responsibility for the delays and ensure that judicial orders are actually implemented without any further hindrance. That is something that is super important for us to comprehend again from the word go. Let's also talk about the legal in terms of strategic examination of the so-called treason allegations against Dr. Kiiza Besigye, because again that becomes the dicey one. Because you see, that's where the issue is being brought to light. Because many are saying, wait a minute, this is a serious crime, and you also rightly said it, this is a serious crime. So, but when you're arguing that, we have to argue it in terms of the intersection of law, politics, and national security, which presents one of the most complex challenges for any government, particularly when they're dealing with high-profile opposition figures like the likes of Dr. Kiiza Besigye. So, allegations of treason are one of the gravest offenses under Uganda's legal framework, no doubt, and therefore must be handled with utmost precision, with legality, and with strategic foresight to balance state security, constitutional rights, and Uganda's international obligations. That we cannot deny or even take away. Okay? Let's also argue, in light of this, history has shown that the manner in which government, for example, responds to political dissent, particularly treason allegations, can actually shape the trajectory of national stability and international credibility. So in this discourse, I will try to delve into constitutional, institutional, even international legal considerations that surround such a case, and I'll try to dissect it in light of the following argument that are prepared for me, bearing in mind, as I said, the seriousness of the offense. First of all, the legal framework in terms of governing treason under Ugandan law and the fundamental rights afforded to any accused individual should be scrutinized, observed or analyzed in light of what I'm going to say. Yes, because this is extremely important. Number two, we have also to understand that the potential in light of the breaches of constitutional or even regional and international human rights are also fundamentally important if due process is not followed. And that is something, again, we cannot take away from this debate that we're having today. These are serious questions in terms of constitutional interpretation, but in terms of the human rights possible violations that are likely to occur if we do not take these things very seriously. So that's the argument we're trying to propound today. Now, the political and diplomatic consequences of mishandling cases, including potential sanctions and civil arrest or even civil unrest, can also have reputational damage in light of this particular question. So it also brings brings to light how serious this issue is, and then the available legal remedies for Dr. Besigye should actually be also looked at in terms of unlawful detention, for example, or denial for due process, which also becomes another question of debate in light of what we are arguing today. Now, we could also look at some strategic recommendations in terms of the government, in terms of handling matters within the boundaries of, or within the bounds of legality, ensuring that security without compromising democratic principles becomes essential in light of what we're discussing today. And so these are also fundamental points that we need to comprehend, even as we argue the challenge that we are having as a nation today in terms of constitutional challenges, which can ensue into a constitutional crisis if we do not have substantive guidance. So the broader context in terms of governance, in terms of this issue, transcends, in my opinion, a single individual. It is a test of Uganda's legal institutions, in terms of constitutional integrity, in terms of political maturity also. So the government must therefore tread carefully, balancing justice with diplomacy, for example, law with pragmatism on the other hand, and also national security with democratic governance. And that is something we cannot take away, my friend. So I'm going to embark on a critical examination within, in terms of an unwavering commitment to substantive truth, in terms of justice, but also in terms of the rule of law, how the rule of law plays out in light of the challenges that we are having as a country today, in terms of this so-called constitutional crisis that is evidently strong enough to lapse into some other things if we do not handle it in a wise and prudent way. First of all, let's address the why, the fundamental principles of habeas corpus. Yeah, the whys in terms of what is habeas corpus. Habeas corpus basically would be an option because it's not just a legal doctrine, but it is a bedrock for constitutional democracy, a safeguard against tyranny, for example, and a weapon against arbitrary state power. Yeah, and it exists to prevent the state from wielding detention as a political tool, ensuring that no individual is actually deprived from liberty without due process. Yes, and again, this particular case of Dr. Kiiza Besigye epitomizes the very reason why habeas corpus is indispensable. When political dissent, for example, translates into legal prosecution, in my opinion, the judicial must serve as an ultimate, bastion of justice in light of what we're trying to comprehend today. Yes, and now let's address the house. If you're talking about the house, then the question is the state's defiance and the legal breach is in the contextualization of the house. The Ugandan Constitution, first of all, and also the Judicial Act and the International Human Rights Instruments unequivocally enshrine habeas corpus as a non-negotiable right. Yes, yet protracted delays in Dr. Besigye's case expose even a blatant disregard for legal obligations. So that is something again that we have to understand from the word go. Now, if we comprehend the discussion further, we could argue in terms of the violation of constitutional timelines. When you argue Article 23, Sub-Article 3, mandates that a detainee has to be brought before a court within 48 hours. Yeah, and the Attorney General's hesitation to process the application in terms of the High Court's reluctance to act swiftly floats this fundamental rule. I'm reliably informed as of today, as of yesterday, I think the Attorney General probably signed the habeas corpus, and that's good news. But then we are also arguing in terms of the time frame. And also, let's look at another point in terms of judicial paralysis or political interference. Yes, the delay raises the specter of state interference in judicial processes, suggesting that legal mechanisms are actually being manipulated to serve political ends rather than upholding justice. And that is something, again, we need to comprehend in light of the discussion we're having today. Please let it be noted that mine is a question of constitutional interpretation and legal debates, in terms of without arousing any feelings or hurting any feelings. It's a constitutional debate. How about contempt of court in terms of executive overreach? The failure to comply with habeas corpus orders, in terms of processing them expeditiously, constitutes not just a breach of duty but a contempt of court, and this undermines the separation of powers and weakens the judicial authority. And so, even as we are excited about tomorrow being the day, we have to be very mindful that the delay in light of the application for the habeas corpus is not delayed in any way. In terms of the consequence, we have to be careful because this may also have substantive consequences. The price of ignoring the rule of law, for example. Yeah, the state's failure to uphold the habeas corpus, for example, in Dr. Besigye's case, is not just a legal anomaly. It is a direct threat to Uganda's constitutional order, and the consequences are far-reaching than simply what we can see as of today. And these are substantive things that we need to look at and appreciate and contextualize in light of the future of this country. In terms of the erosion of the judiciary integrity, for example, when courts become instruments of executive control rather than arbiters of justice, then public confidence in terms of the judiciary will actually collapse. And therefore, courts have to be very firm and be very affirming in light of their independence. And then international and legal repercussions. Uganda's obligation, for example, under the ICCPR, for example, or even the UDHR, or even the SCHPR, demand compliance with due process. Yeah, persistent violations, for example, could actually attract international scrutiny on sanctions and even legal actions before regional human rights bodies, and therefore that becomes again something super important for us to comprehend in light of the prospective challenges that are likely to ensue our country if we do not address these particular matters. In terms of setting a dangerous precedent, if the state can actually defy habeas corpus in one case, it signals that no individual is safe from unlawful detention. I think that was rightly said by the right honorable speaker today. Not so. It signals that no individual is safe from any unlawful detention. So what begins as a political suppression, mastermizes into a culture of impunity, and that is what was proponed by honorable Anita Among when she rightly pointed that out. And then in light of legal remedies and resistance, the legal team has actually multiple avenues in terms, including obviously constitutional petition, judicial review, and also content proceedings. If, for example, domestic remedies fail, then you can bring in international legal reforms in terms of as an option in terms of addressing this particular challenge that may be facing the country today. And therefore, the question perhaps again that I'd like to address is then what then becomes the defining test for the rule of law. That is something that again we need to comprehend from the word go. What then becomes the test for the rule of law? If you're arguing in terms of the habeas corpus application for Dr. Besigye, it is more than just a legal matter. It is a litmus test for Uganda's commitment to justice. Yes, and the outcome will therefore reinforce the rule of law or expose the judiciary as complicit in terms of political repression. Yes, and therefore the question is simple: will Uganda, for example, uphold its own legal seal, or will it tear down the very foundation of justice? That is the question perhaps that we're looking at today. And these are substantively very important aspects. They may be simple, but they have far-reaching consequences in light of constitutional jurisprudence in terms of this country. And therefore, dismantling aspects of habeas corpus in Uganda becomes a legal, and political substantive debate for us today. And let's first of all argue in light of what they call the legal bastion under siege. That's what I would want to call it. It becomes a legal bastion under siege. So habeas corpus, as I say, often heralded, as the great writ of liberty, is a fundamental legal safeguard against arbitrary detention, just like we are seeing in light of other people. Okay, and therefore it's an ideal form. It embodies the principle that no one, regardless of their political, persuasion or even social status, should actually be deprived of their liberty without due process. So the question is, however, in Uganda, as a legal and political landscape, we are presented with the grim of paradox. Yeah, while habeas corpus remains codified within the laws, its effectiveness is systematically eroded, in my opinion, by state action, and that is the question of the day. Will the state do well in light of this, or will it do bad in light of this? So in the case of Dr. Kiiza Besigye, the recurrent victim of politically motivated arrest, for example, epitomizes the Ugandan state defiance in terms of judicial authority. So through legal gymnastics, administrative bottlenecks, for example, and even outright contempt of court rulings, the executive has reduced habeas corpus to legal fiction rather than an enforceable right. And the discourse therefore integrates the broader implication of such constitutional erosion and the state calculated defiance in terms of legal norms and the urgent need for remedial actions. So my friends, we're talking about super serious business here. We're talking about a non-derogable right, which we cannot tamper with. If we begin tampering with these, then we're going to find ourselves in serious consequences as a nation, as a people, as a creed, as a kindred. That is something we must understand. If you're arguing habeas corpus, it becomes a constitutional guarantee or a political mirage in terms of a debate. That's something I'd like to argue. Will it be looked at as constitutional guarantee or simply a political mirage? The Constitution, 1994 Constitution, particularly under Article 23, unequivocally guarantees the right to personal liberty and the right to challenge unlawful detention. So the Judicial Act further even empowers the courts to issue a writ of habeas corpus where the individual is actually upheld or held unlawfully. However, in practice, these guarantees are actually systematically undermined, as I say, by state thoroughness or by state mandates, if you may choose that word carefully. Now, perhaps some of the ways they will do that is tactical defiance of court orders. How often have we seen this happen? Yeah, despite judicial pronouncements, for example, the executive or through even security operatives frequently ignore or even delay these or even circumvent these so-called court rulings, and that creates a super super serious problem for us to fight. And therefore, precedents exist where law enforcement simply refuses to produce detainees in court, rendering the writ ineffective. And that's a fundamental breach in light of constitutionalism of our country. And this is something, again, that I'm emphasizing from the word go, that we just cannot take away. We cannot rule away, because this becomes substantively important if our nation is to thrive in light of constitutionalism that we so much pride in as a nation, or any other country for that purpose. In terms of revolving door detention, for example, in terms of the state's evasive tactics, for example, in cases like Besigye, for example, the police and the military have actually perfected the art of catch and release. Remember that? Rearresting individuals immediately after their court mandatory release. How often have we seen this being played in our faces in this country? And that is a super serious problem for us even as a country. So the tactic basically neutralizes this so-called habeas corpus, ensuring that even when courts intervene, the executive remains in control of a person's liberty. So I would not be surprised, for example, if, for example, after a habeas corpus has been had and someone is released and then immediately they're actually arrested. That becomes a serious problem in light of constitutionalism in this country, and that is something we're talking about. Some of you are probably very aware of what has happened before in this country in light of those particular playouts. In terms of the judiciary compromise autonomy also, judges often issue habeas corpus knowing they actually will be ignored, signaling a judiciary with power in theory but none in practice. As I already made that argument, where the judiciary becomes more executive minded than executive itself. And these are substantially important aspects. So the fear of the state reprisal, for example, against judicial officers further, curtails bold rulings that could actually confront executive impunity. And this is something, again, that we have to look at when we're arguing and making this substantive discussion in light of constitutionalism as a case for our country, in light of Dr. Kiiza Besigye's challenge that is facing today, in light of the most pending appeal or most pending application in light of a habeas corpus that will ensue tomorrow. So even as we debate some of these things, we have to be very mindful that it's important as a nation and as a country to be mindful of following these constitutional guidelines, because after all, they are the bedrock of human rights. And so the question of Besigye then becomes a conundrum in terms of political persecution. So we could argue Besigye's case as a conundrum in terms of a case study, in terms of political persecution. Dr. Besigye's obviously history in terms of the state and Uganda reflects Uganda's paradox in terms of legality and illegality. He is multiple arrested, for example, on charges ranging from treason to public nuisance, underscores the state resolve to neutralize opposition through legal machinery rather than open democratic engagement, in my opinion. And that is substantially something that has played out on him over a period of time. I think he's probably one of the most, without being perhaps unfortunate politician in one or the other. And then the pattern of suppression. Each of Besigye's arrests, flows a predictable pattern. He will be arrested, he will be detained, and then a habeas corpus writ may be, issued, and then it will be ignored by court, and then another order, and then released, and then rearrested. So there is already a pattern that we seem to have, very well. So the state's intention not to prosecute, but for perpetual dispersion, a strategy designed to exhaust or even discredit or even marginalize opposition figures is likely to happen or to ensue. So we're not really very we're very positive in light of substantive legal redresses that are likely to ensue out of this case, as I just said. And then the aspect of selective application of the law. While opposition figures like Besigye, for example, or even Bobby Wine, perhaps the likes of Stella Nyanzi, or even other people, name them, face substantive legal prosecution. State-aligned individuals evade accountability despite clear legal infractions, and that is something that again you may want to comprehend again from the word go. So this selective injustice, dismantles the foundation in terms of the principles of the rule of law, replacing it with the rule by decree, which substantially becomes a very big dilemma for us as a country that has so pride so much in the ideal of constitutionalism, especially the childbirth of His Excellency, the 19th century Constitution, which he takes pride in as having fundamentally brought about a fundamental change in the politics of this country. So some of the things we need to comprehend have to be argued in the context of the overall picture. It's not one thing to move on the left and then forget the right. It is something we have to work together in light of creating a future that is substantive enough for our children and grandchildren that are going to come after us. And then what are some of the substantive consequences that may lead to a dysfunctional habeas corpus regime, for example? When habeas corpus, for example, loses its authority, then the implications extend far beyond individual cases. As I just argued, we are now not looking at ourselves anymore. We're looking at those that are probably coming after us in terms of creating a foundation for tomorrow. In terms of judicial redundancy, for example, and the normalization of executive impunity, we could argue that that is substantive that is likely to happen. There could be, redundancy and then complacency in terms of normalization of executive impunity. So the legal system where court rulings are routinely disregarded signals the judicial's diminishing role in terms of governance, and this is something again that you have to comprehend again and understand from the word go. And then the executive assumes unchecked powers in terms of replacing constitutionalism with authoritarian discretion, and that becomes another substantive serious challenge for us as a country in terms of comprehending whether or not we should continue on the same platter, or it's time to address some of these particular issues. And then there's substantive issues in light of what they call chilling effect on political dissent. Arbitrary arrests may actually create a culture of fear among activists, even journalists, for example, and even political opponents. And that is substantive enough for us to see, and in terms of what has happened, perhaps with the likes of those who have come out very strongly to oppose the regime. So the state's message becomes very clear: law is not a shield for the people, but a sword for the government, and that is something we have to also be lookout for in light of constitutionalism of this country. So these begs bigger questions than what we are seeing today. Is it a reprisal? Is it a question of knowing how to play your game so that you can extend your longevity in terms of the powers that be? Or is it something that we're having shortcuts or lacunas within the concepts of the constitutional debates that we're arguing today? In terms of Uganda's continued violation of civil liberties places it under scrutiny, by the way, in terms of international bodies such as the African Court on Human and People's Rights. We are under substantive scrutiny under these international bodies, the African Court on Human Rights and People's Rights, and then the United Nations Human Rights Council, for example. All these will look and study and see what we are going to do or how we are addressing some of these challenges. We may brush them off and say these are not our things, but they affect us in one way or the other. So, and they affect our bread and butter at the end of the day, because who knows? We all know that we depend largely in light of what comes from them. So the state's intransigency in terms of the risk, the economic or even diplomatic consequences, including reduced foreign investment and aid restrictions, become fundamentally a question of suspicion, as I just argued out in terms of that particular contextualization of the point that I made. So we have to be careful that whatever decision affects our brother or our sister substantially will affect us indirectly, and that is something we need to look out in terms of creating a future, as I said, for ourselves, but even for those who are coming after us. And then in terms of the path forward, in terms of restoring the integrity of habeas corpus, for example, what are some of the takeaways? What are some of the things that we could look at in terms of this? We could look at it in terms of embodying or perhaps creating what they call judicial boldness and structural reforms. Yes, the judiciary, in my opinion, must assert its independence by actually enforcing contempt proceedings against the defiant state officials. Yes, and that is perhaps a test that's going to come today. If, for example, the court rules and says we've issued the writ of habeas corpus and we have granted it, and the powers that be deny it, can they take action against them? So legal reform should actually introduce criminal penalties, for example, for ignoring habeas corpus orders, ensuring personal liabilities for these violators, and that becomes another test for us that we are eagerly looking at in terms of jurisprudence of our country. Perhaps we will see it for the first time when these orders are taken against them in light of breaking of breaches, or in terms of not obliging with the court decision. Legislative oversight and constitutional amendments could also be looked at. Parliament must introduce these legislative mandating automatic penalties for non-compliance with court orders. That becomes another substantive important aspect in terms of enforcing the powers that be in terms of legislative authority. So legal provisions must actually criminalize revolving door detention, for example, ensuring individuals are not rearrested without new charges. That is something that we need to comprehend, because we have seen that again being played out on and on and on in light of our country. And these are things that we are thinking, God have mercy. Will there be a day when we believe in the strict interpretation of the Constitution in terms of black and white, without putting in shades of gray? And then strategic litigation in terms of international recourse, for example. Opposition figures and civil society organizations should also escalate cases in terms of regional and international courts, for example. That's another possibility, yeah. And we cannot rule that away. We cannot rule that away. I'm sure that some of the things are happening on a bigger front, but we have not had much coverage in terms of media. But legal activism through organizations like the East African Court of Justice can generate binding precedents in terms of against arbitrary detentions. And this is something that, again, that is extremely important, that we cannot hide or even take away in light of the constitutional debate that we're having as a country. And then we could also argue in light of what they call civic engagement and even public accountability. That becomes fundamentally important. Yes, Uganda, for example, in light of Ugandan public must actually demand the sanctity of the legal process, recognizing that the erosion of one's right endangers all rights. And that's the point we are just saying. If the Kenyans can think of mobilizing and, on behalf of, Dr. Kiiza Besigye in light of civilian or rightful protests, how much more? So we have to strengthen the media in terms of independence, in terms of investigating journalism, for example, exposing human rights abuses, and also creating sustained domestic and international pressure, like I just pointed out, in light of what the Kenyans are likely to do. So in terms of habeas corpus being a litmus test for Uganda's democracy, becomes a super important aspect for us today and for tomorrow. So the state, in my opinion, the state's recurrent defiance of habeas corpus becomes not merely a legal dilemma, but a test for Uganda's democratic trajectory. So it's fundamental, in my opinion, that such a right as personal liberty can actually be disregarded with impunity. Then constitutionalism is in dire jeopardy, and democracy, in my opinion, is merely performative, and that becomes super dangerous for us as a country. So the point here is that habeas corpus is not just a procedural formality; it becomes a last line of defense between lawful governance and tyranny. Its violation is not isolated in terms of issues affecting Besigye or even political position alone. It is a collective assault on every Ugandan right in terms of justice, and that is something you cannot take away from this particular constitutional jurisprudential debate that we're having today. So the question, therefore, remains: if habeas corpus is rendered ineffective, what safeguards remain to prevent Uganda's descent into full-fledged authoritarianism? And that is something that we can have also, we can contextualize in terms of the discussion that we're having today. In terms of constitutional, in terms of local, in terms of international legal breaches, in terms of Uganda's disregard of the habeas corpus, what are the likelihood, consequences that can play out for us? The point here is that Uganda's systematic violation of habeas corpus, especially in cases of like the ones of Dr. Kiiza Besigye and multiple arrests, raises, in my opinion, significant constitutional challenges in terms of statutory, in terms of international law breaches, for example. And the state's actions not only contravene Uganda's legal framework, but also violate regional and international human rights obligations. So I'm going to try to give a legal analysis in terms of these breaches and their substantive consequences in terms of the challenges that await you and I if we do not follow and oblige or pray perhaps that the powers that be, especially judicially, affirms itself, and every self-full individual in this country who believes in the Constitution does the right thing, because after all, the Constitution, as we say, is the grand norm, not so. So in terms of constitutional breaches under the Ugandan law, we are likely to have violations of the right to personal liberty, and that means that's a direct infringement on Article 23 of the 1995 Constitution of Uganda, which explicitly provides for the right to personal liberty and outlines conditions under which a person can actually be lawfully detained. And such key breaches obviously would include substantive challenges, and some of them you need to look at Article 23 sub-Article 1, which said that no person shall actually be deprived of personal liberty except in accordance with the law. And that is something that is super important. In terms of a breach, arbitrary arrest, for example, without due processes violates this provision, and that is something we have to look out for in terms of comprehending the discussion that we're having here today. My friends, this is serious stuff that we're talking about. This is not a mere a cup of porridge. to use that phrase, but this is substantive business because it affects you and I. If you argue in terms of what Article 23 sub Article 4b, that requires that every person arrested on suspicion of committing an offense must actually be brought before court within 48 hours. That, my friend, is super serious business. And how many times have we seen people who have been incarcerated for more than 48 hours? That again becomes a serious breach in light of Uganda's security agencies that often detain individuals for days or even for weeks without trial in clear violation of this particular requirement. And that again is another painful and hurting issue that how I wish shouldn't occur in this country on anybody in any way. And then if you argue in light of Article 23 sub Article 3, which mandates that any person unlawfully detained is entitled to compensation from the government. How many times have we seen people who are just thrown away, perhaps thrown on the streets, and even without substantive compensation, in spite of their breaches, in spite of the infringement of their own right? So the state rarely compensates victims when it comes to legal detentions, rendering this provision very ineffective. So that is something again you may need to think about and to pray about, perhaps as a country, in light of the constitutional jurisprudence of this nation. This is serious stuff that we're talking about here. It looks simple, but as I said, it's bigger than what? Than Besigye as an individual. I would borrow the words of the Right Honorable Speaker today. I was so impressed by the statement she said, if we do not do something, this could happen to the next person, and what will happen when the day comes. Yeah, and then the aspect of contempt of court and undermining judicial independence, for example. Yeah, these are some very important things that comes into play. For example, Article 128 guarantees judicial independence, for example, prohibiting interference in terms of judicial decisions. You may want to remember the poem that was proponed by Justice Ogola, remember, yeah, the rape of the temple. So some of those things become substantially important, but they are creating jurisprudence for this country, and that's how perhaps certain regimes will be known. Look at Article 128.1 states that courts shall actually be independent and not be subject to the control or in the direction of any person or authority. Yeah, and in terms of breaches, the executive defiance, for example, or substantive court orders, for example, refusing to release detained individuals directly undermines judicial authority. Yes, and say we are saying regardless of the offense. I mean, we believe in the presumption of innocence. At least that's what the Constitution tells us to. Yeah, a person is innocent until they're proved guilty. Not so. How about those aspects? What happened to those? If you didn't want them there, then you shouldn't have put them there. How about Article 128.3 that prohibits any person, including government officials, from interfering with judicial decision? How often do we see, this interference taking place? Yeah, repeated refusal, for example, to comply with habeas corpus rulings amounts to executive operations. And these are things that bother you and me, and also are creating bad precedent for our country in terms of the better tomorrow. And as long as we don't address these substantive challenges today, be aware, be mindful that they're going to knock on our doors tomorrow. A time has come where we need to follow the Constitution. If we have chosen the Constitution to be our guideline, if we have chosen the Constitution to be our grand norm, let us follow it to the letter. Because after all, that is what we chose to be. We did a constitutional review commission, and then people moved around the nation and then agreed on principles. Yeah, how about the abuse of emergency powers in terms of unlawful detention? Article 44D provides that the right to habeas corpus is non-derogable, meaning it cannot be suspended even during emergencies. Think about that. It cannot be suspended even during emergencies. Yeah, what are the consequences? Ugandan government has actually used sometimes security justification, for example, terrorism or public order laws to indefinitely detain individuals directly violating this Article 44D, which substantially is an non-derogable right, as you just argued. How about if you argue in terms of Article 212, yeah, that mandates that security forces, including the police, must actually be accountable to the law. Yes, these are substantive important things in terms of unlawful detentions, enforced disappearances, for example, the police brutality that demonstrate clear disregard of these provisions. And these are things that you and I, my friends, need to think about deeply if we are to be the next custodians of this country, or perhaps of this nation, or if we're to teach our kids and grandkids to follow the principles of democracy. As I said, this is something that we created. This is something that broke people's backs, traversed the entire nation, and it is something we need to look at in terms of that. Now, I'd like to argue briefly in light of breaches of Ugandan statutory laws, for example, in terms of non-compliance with the Judicial Act, for example, and then some substantive international obligations or perhaps international laws to that effect. We are aware that the Judicial Act, for example, empowers courts to issue writs of habeas corpus as provided for under Section 36, and that is substantially important. As a breach, for example, the refusal, in my opinion, for the security agents to present the detainees before the court after habeas corpus applications, in my opinion, violates this particular law, and that is something that you need to again understand, that we have to be careful that we, even as we execute whatever mandate has been given by us, we should not violate the bigger question of the Constitution, because after all, every other law that is inconsistent with the Constitution becomes null and void to the extent of what is inconsistency, and so that becomes very important in light of that. In terms of the violation of the Penal Code Act, for example, substantive provisions also are there in light of that. If you look at particular sections within the Act, the PCA, for example, it criminalizes unlawful detention by public officials. Yes, and therefore that also becomes something important for us to look at. The state operatives, in most cases, frequently detain individuals without cause, and yet these are not prosecuted. And you can visit Human Rights Commission, and they have substantive evidence to that effect in light of that. And so many of the things I'm talking about are not just coming out of my head, but are coming out of research, are coming out of substantive reviews and peer reviews and international opinions that have been documented. And then if you look at the PCS still, it defines the crime of kidnapping or even unlawful confining of a person, for example, which case just happened recently with the likes of kiiza Besigye. And then issues of safe houses, secret detention, for example, that constitute illegal confinement under the provision also become a substantive issue to address as a country. And so these are substantive issues that we're not just picking out of the sky or out of the air, but these are things that we're getting from the very facets of the law that have been propounded or made by this beautiful country called the Pearl of Africa. And how I wish we live to the true creed of the true meaning of the Pearl of Africa in light of these particular issues. How about issues in terms of the breaches of the Police Act, for example? Yes, the Police Act basically mandates that arrests must follow due processes and must be backed by clear legal grounds, and these are substantive provisions in light of that context as well, and then there are particular sections, for example, that require detained individuals, for example, to be informed of the charges against them. Yes, and that is something important. Probably section 242, you may want to double check that. But in light of that, there are many detainees, for example, including opposition figures, for example, who are held without being informed of any specific charges, and that, in my opinion, becomes a breach in terms of their constitutional right, because after all, they are protected by this constitution in light of their safeguards against any arbitrary abuse by any individual, whether it be the police or any security organ for that purpose. You may also want to look at in terms of prohibition for detention without trial, for example. Security agencies frequently ignore this provision, leading to unlawful detentions. You may want to double check with section 25 again in light of those particular contexts, in terms of how that becomes a big question of debate for our country today in light of constitutional provisions in safeguarding human rights as a general perspective, in terms of what works and what doesn't work for our liberty, for our freedom, for enjoyment of these so-called human rights that we claim are God-given or perhaps man-given. That's another question of debate. And then if you have to look at international and regional legal breaches, then you may want to contextualize in terms of the violation of the Universal Declaration of Human Rights, what they call the UDHR of 1948. That is a fundamental instrument that we need to look at as well. Yeah, the Uganda, basically being a member of the United Nations, is also bound by UDHR, which basically guarantees fundamental freedoms, substantive aspect in terms of that. And particularly under Article 3, it guarantees the right to liberty and security of the person. And that is substantially important for you to understand again, or to take away from the word go. It's super important because it lays bare the things that I'm talking about. Then you may want to look at Article 9 also, which prohibits arbitrary arrest and detention or even exile, for example. Again, another important aspect in light of again breaching or perhaps laying a strong foundation for constitutionalism in light of our country. And a breach, definitely we could argue that Uganda politically motivated arrest, for example, and indefinite detentions violate these provisions. You want to look at some of those cases that are played out in the case of Uganda before. without even mentioning names, we can figure out who and what are some of those particular injuries that have actually been breached. And then we could also look at, in terms of the breach of International Covenant on Civil and Political Rights, what they call the ICCPR of 1966. And the argument here being that Uganda ratified the ICCPR, making it legally binding. And these key provisions basically violated include substantive arguments in terms of certain provisions. For example, if you look at Article 9.1, that no one shall actually be subjected to arbitrary arrest or detention. And that is fundamentally important because it's provided for under the particular instrument. And then you look at Article 9, Sub-Article 4, where anyone deprived of their liberty by arrest or even detention shall actually be entitled to take proceedings before a court. And that is substantially important, again, in light of what we're talking about today. So again, everything that we are trying to talk about here is fundamentally important, whether nationally or internationally. Look at Article 14. Also, it talks about the guaranteeing of a fair trial and legal representation, again, substantially also addressing the questions that we're talking about today. We just can't shy away from these fundamental obligations that we hold so dear, and we pride as a nation, as I said, the Pearl of Africa. Not so. Uganda's up, like they say. So how about Uganda's refusal to produce detainees in court, which violates this provision? These are fundamentally breaches that are likely to not sound so well internationally, because then they shed a bad light in light of what our country is, or what we claim we are, and yet we are in most cases not. In terms of the violation of the African Charter on Human Rights and People's Rights, for example, what they call the SCHPR of 1981, Uganda is bound by SCHPR, which promotes human rights across Africa, and the violated provisions could include some of the following. For example, you may want to look at Article 6, for example, that talks about which prohibits what they call arbitrary arrest and detention. Yes, it lays bare in light of that. Look at Article 7 also, which guarantees the right to be heard in terms of a fair trial. Yeah, in terms of procedures, for example. All these are fundamental aspects that Uganda cannot shy away. So when you look at these particular cases that are playing out today in light of Besigye or any other person, you are looking at a smaller, but there's a bigger picture, and that's the point I'm trying to make here. So the state's disregard for court rulings and prolonged detentions breach these fundamental rights, and these, in my opinion, have a say on us as a country, or whether an individual or as a country, and that is something we cannot shy away. We have to just be very firm. We have to keep reminding the powers that be, to remind everyone that we are bound by the institutions, regardless of how terrible we might want these things not to work against particular individuals. But they are law, and the law has to be, obliged. And then the breach of the East African Community Treaty, for example, of 1999, for example. As a member of the East African Community, for example, Uganda is legally required, for example, to uphold human rights. Not so. And these are fundamentally important. We pride ourselves in Africanism. Not so. The argument of wanting to create the East African Community. And when you look at Article 60, for example, of the East African Community, it mandates that member states adhere to democratic principles and human rights. Yeah? Look at Article 7 of Article 2, which requires the respect of the rule of law and even good governance. These are fundamental important things that you cannot shy away. You cannot shy away. And my approach, my discussion today is not geared at any particular individual, whether the president or what, but it's geared at all people who believe in the right to true constitutionalism in this country. Yeah, in terms of laying a basis for us to follow tomorrow. Uganda's consistent violations of habeas corpus undermines the obligations under the East African Community framework, and this is something we cannot be seen to break. We have to learn better than ourselves. However uncomfortable some of the things may be, it's important for us to understand that this is life, and we have laid the yardstick. We have decided that we're going to follow, and let's follow. In terms of legal recourse and remedies, given the widespread breaches, several legal actions can actually be pursued, in my opinion, because I've talked about the breaches, I've talked about the challenges, and now perhaps in terms of the remedies, maybe we need substantive domestic litigation, for example, in terms of filing contempt of court cases against the government, for example. Yeah, officials who ignore court orders, I mentioned that, may actually be visited with liability in light of failing to oblige with these particular court orders. Yes, in terms of also petitioning the Constitutional Court to challenge laws or even practices that violate constitutionalism, or the Constitution for that purpose. some of these fundamental. I mean, we can borrow from these examples, and I'm saying that America, for example, is the best example of a democracy. But we know that every time there's a breach, well, it has to do with the president. The long arm of the law will actually tread upon them. And look at how breaches in terms of regional and international legal actions, for example, the African Court on Human and People's Rights, HPR, victims can file, cases against Uganda for human rights violations, in terms of the African Court on Human and People's Rights. And these are substantive redresses, again, that we may think about as a nation, perhaps, and then also in terms of the East African Court of Justice, for example. Also, I've seen substantive arguments that have been propounded by particular individuals, also in terms of remedies to the East African Court of Justice, for example. Uganda can actually be sued for breaching East African Court treaties in terms of human rights provisions, and that is something that you may want to think about. It may not affect you today, but it may have far-reaching consequences. And then the aspects of Uganda, United Nations Human Rights Commission, what they call the UNHRC, in terms of complaints, can actually be submitted under the ICCPR for arbitrary detention cases, for example. These are substantive remedies also that are likely to ensue in the event that there are breaches or there are fundamental abuses that have been occasioned in light of all the things that we're discussing today. So every point that I'm trying to underscore here becomes substantially important. It's not just a question of presenting niceties and making a case for a particular individual. It's a question of substantive constitutional debate that you and I are relying on for our sake, for our children's sake, and for our grandchildren's sake. So my opinion here is, the question is, we may find ourselves facing a constitutional crisis in the making. Uganda's persistent violation of the habeas corpus is not merely a legal technicality, in my opinion. It seems to be a systematic dismantling of constitutional democracy, and the state's defiance of court orders, arbitrary arrests, and politically motivated detentions demonstrate a dangerous shift towards authoritarianism. And that is something we have to take very, very seriously, my friends. So the point is, if these violations continue unchecked, the challenge we have, Uganda risks a lot of challenges. We risk issues to do with, for example, a judicial collapse, where courts lose authority over executive actions, and their hands are just simply tied, and they have nothing to do in spite of what they have pronounced, and then we also risk issues in terms of political instability, as suppression, fuels resistance. That is something you have to think about as well. And then international sanctions as well, reducing diplomatic and even economic cooperation, for example, can also be an offshoot of some of these challenges. So it's not something that we could have to take lightly. It is something we need to think about deeply. It is something we need to pray about. It's something we need to take deliberate action in terms of taking fundamental steps as people who believe in the Constitution. So restoring respect, in my opinion, for habeas corpus requires political will, judicial assertiveness, and sustained legal activism. So, the fight is not just for opposition leaders only, but for every Ugandan who values freedom, who values justice in terms of the rule of law. That becomes very, very important. And the legal remedies, for example, that are substantially presented, I've already made them for the likes of Dr. Kiiza Besigye and any other person, are there for us to take and to comprehend. The question is, will they be respected or will they not be respected? So once again, my name is Isaac Christopher Lubogo. We've just had a small discussion. You find most of our works at lubogo.org or Sue Genesis Law App. Many of the things that we have talked about in our books. God has been gracious. We have about probably 80 books now running, well available, free of charge at lubogo.org. Find them everywhere: Scribd, Amazon, Digital Draft. Find them anywhere in all university repositories in the entire world. The Lord has been gracious, and we're only here to do what we do best in light of enlightening ourselves with the law. God bless you, and thank you for your attention.